Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable?
Of the evil that lurks within, smiling faces, sometimes they don't tell the truth.
And in the exercise of their judgment, they determined, based on the historical use of nets, based on the advice of their experts, that the 2-inch mesh rule would be a reasonable place to draw the line.
The FWC staff has made a great effort to lead the courts to believe that their version of a seine net's historical usage actually relates to today's useless, wasteful net. If you notice on the 2005 FWC PowerPoint for the commissioners, the seines pictured are rectangular, flat, they're without wings, pockets, or braille lines. This is a true historical seine. Note the rounded shape from the cork to the lead line created by the braille lines. 90% of the net was called the wing. This section, representing only 10% of the net, was called the bunt, sock, or pocket. The wings used large mesh to allow the juvenile fish to escape, while the pocket, sock, or bunt was the only part of a historical seine net to use small mesh of 2.5 inches or less. After the juvenile fish escaped through the large mesh in the wings, legal, marketable fish were then herded into the pocket for capture. Historical seine nets had 1/10 the bycatch rate of the staff-designed seine net. When you hear the staff or their attorneys use the words historical usage, remember the truth. Additionally, large mesh rectangular nets historically only had a 3% bycatch average. Throughout this video, never forget that the Supreme Court stated the only purpose of the amendment is the following.
The Supreme Court told us in advisory opinion, the singular sole purpose of the amendment is to protect the resource from unnecessary and wasteful killing of the resource.
Remembering the sole purpose of the amendment, listen carefully to what the FWC admitted in this case.
Counsel, let me ask you this. Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When you ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. 90% of the fish that were gilled
That's what Mr. Maurer just
said.
I'm
not questioning his that. I mean, 90% of the fish that were gilled were juvenile.
Now that the FWC admitted 2-inch mesh nets produced 90% waste, listen to this.
What the hearing officer found 7 years ago is borne out. It was found that the 2-inch net would not, and Mr. Rudlow testified at that hearing too, and he said the same thing in that hearing. And what the hearing officer found, as I read to you before, was there would be no unreasonable amount of unnecessary killing, and it wouldn't hurt the resource. That's what our experts continue to say. That's what our affidavits continue to say, and that's what the statistics bear out.
For over 10 years, the FWC legal staff have relied upon a 1997 court decision that was proven to be based on false testimony. Listen.
The hearing officer in paragraph 55 of the order, back on the rule challenge, said, quote, no dangerous level of unnecessary killing or waste will occur.
Counsel, let me ask you this. Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish? When you ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. 90% of the fish that were gilled
That's what Mr. Maurer just said.
I'm not questioning his that. I mean, 90% of the fish that were gilled were juvenile.
Upcoming, remember the 2-inch mesh became rule in 1997 before the MFC FWC ever tested a 2-inch mesh net.
I'm sorry, if I might ask a question.
I'm sorry.
I would like to know if the evidence has been presented to the trial court was presented at the time the ALJ entered the ruling that you just quoted to me?
The specific test that they're talking about was not. But there was evidence and opinion testimony presented to the hearing officer that allowed her to make those determinations. In paragraph 37 of the final order, the hearing officer says, in formulating the proposed rule, the commission was presented with extensive comments, technical information, and post-amendment updates of earlier surveys. The specific evidence was not presented. Of course, it wasn't generated until last year.
In addition,
Since then, in 1998, we submitted independent tests conducted at the FWC. Summarily rejected, refused to look at them.
as a result of the staff's rejection of our tests, it took 8 years to force the staff to conduct tests that proved the 2-inch mesh nets were wasting the resource at a 98% rate. Ready to hear a little more insanity?
The selection of 2 inches in paragraph 76 was historically based, rational, and practical.
Here's what the FWC relied upon in this case.
The only case that's really relied on by the Attorney General is the old 2-inch rule case, which went to an ALJ, and that concerned a seine net. The finding was the testimony of Mr. Brent Winter and Mr. Russell Nelson was that less than 5% of the fish caught would be bycatch, 5% max. Now we know it's 90%. Is that a problem? That's a serious problem.
So what did Mr. Brent Winter say in his deposition 8 years after telling the ALJ that there would be a negligible amount of bycatch with 2-inch mesh nets?
Their own expert said in a deposition, if there is a substantial bycatch, that's not good for resource protection, contrary to his opinion 8 years ago in the 2-inch rule case.
But
why shouldn't it be considered when you get better data, and newer data, and as I understand, your client agreed with the appellant to go out and test these nets, and when the results appeared to be adverse to your client's position, then the tests were terminated. Is that a...
That is not, absolutely not what happened, Your Honor.